evening and welcome to LawSikho's thorough newspaper analysis for the 4th of July 2023. So today we have one editorial article which has been taken from the Hindu and is titled A Case of Unchecked Power to Restrict E-Free Speech. And it talks about the Shreya Singhal judgment and the recent High Court judgment that undermines the same. For the second and the third segment, we have the news update and the legal news. So, firstly, the issue is into the light because on the 30th of June 2023, the Karnataka High Court went forward and dismissed Twitter's challenge to the issuance of blocking orders that had come from the Ministry of Electronics and Information Technology, which is better known as MeitY. Now, this was in connection with the taking down of Twitter accounts and specific tweets. The High Court admonished Twitter for not complying with the orders and imposed an astounding cost of rupees 50 lakhs on the United States-based social media company. Now, when we talk of the state's power to bring down content on social media platforms or suspending accounts as a whole, the first and the foremost precedent that we have to deal with here is the Shreya Singhal judgment. And this is a holy judgment when it comes to taking down of content. Hence, it was surprising when the Karnataka High Court went forward and held that the Shreya Singhal case does not mean providing notice to the users of the content, and that even if reasons for the same had been recorded in writing, they may not be conveyed to the users. Now, what the High Court essentially does is that it goes against a very holy grail sort of a judicial precedent and provides unfettered power to the state to take down content. Which content, you may argue? Contents which go forward with criticism against the government or dissent against the government policies. Now, the observations have their criticisms in multi-tiers. Firstly, the HC held that the state could exercise its discretion to hear users and that issuance of notice under Rule 8 was not mandatory. The court also held that the users were not handicapped due to the imposition of such account or tweet suspensions. Now, when we are talking of criticism or dissent against the government, we must notice that although it may not physically handicap the users, but it is the handicap of truth. Because what may often come as a form of dissent might be the truth that the specific government is alleged to be burying. Secondly, the court had also stated that if the account suspensions or the redactions in the tweet were so severe, then people would have approached the court and cases would have been initiated against the government. Since this had not happened, we can safely, like the court could safely conquer that this was not a major issue. Now, this view is not the truth in its entirety. There were people, there were social activists who had gone forward and filed cases against their accounts being taken down or their tweets being suspended because they were dissenting against some sort of a government policy. It was the court that did not take cognizance of the complaint and stated that this was like making a mountain out of a molehill. And hence, it would not be correct to say that no one approached the court with the issue, but it was rather the court who did not take cognizance. Now, one must remember that when we go forward with reasonable restrictions that can be placed on the fundamental right of freedom of speech, the government can only move forward with such restrictions if they satisfy the 8 grounds which have been enumerated in Article 19, Subclause 2. The High Court stated that there were reports of fake news which could have incited violence. However, firstly, fake news in itself is not a ground for restriction of free speech. Further, with regards to inciting violence or disturbance in public order, the Supreme Court has repeatedly held that for speech to be prejudicial to maintenance of public order, there must be a direct link between the speech and the potential threat to public order. Even in the case of Brij Bhushan and another versus the state of Delhi, the Supreme Court held that pre-censorship on freedom of speech is unconstitutional at its core. Now, for the news updates of the day, we have Dream 11 secures BCCI lead sponsor rights. The Board of Control for Cricket in India was pleased to announce Dream 11, India's biggest fantasy sports gaming platform, as Team India's lead sponsor for a period of 3 years. Dream 11 will be seen on Team India jerseys starting from the Test series against the West Indies, and the team's first assignment is the ICC World Test Championship 2023-25 cycle. Secondly, we have Startup20 Shikhar Summit under India's G20 presidency begins in Gurugram, Haryana. The Startup20 Shikhar Summit under India's G20 presidency began in Gurugram, Haryana. The Startup 20 group is hosting the two-day Startup 20 Shikhar Summit. Speaking on the occasion, Minister of State for Commerce and Industry Som Prakash said, education and awareness play a vital role in nurturing a culturally sensitive startup ecosystem. On the occasion, G20 Sherpa Amitabh Kant said, in India, the total investment in startups has gone up to 19 times. He said that there is no shortage of funds for good startups with strong business models. Thirdly, we have boxing champion Mary Kom named Global Indian Icon at the UK India Awards. Now, in a proud moment for India, sporting legend and India's first ever Olympic medalist in women's boxing, Mary Kom has been honored with the Global Indian Icon of the Year award at the annual UK India Awards in Windsor, southeastern England. The 40-year-old former Rajya Sabha member spoke of her 20-year journey of hard work and devoting her life to boxing as she accepted the award from Indian High Commissioner to the UK, Vikram Doraiswamy, at a gala ceremony on the 29th June 9th. For the international news segment of the day, we have Iran to join Shanghai Alliance with China and Russia. Iran will be formally approved as a member of the regional Shanghai Cooperation Organization with China, Russia, and Central Asian countries. Iranian Foreign Minister Hossein Amir Abdullahian later had a phone conversation with the Secretary General of Shanghai Cooperation Organization, Zhang Ming, Iran's foreign ministry said. Secondly, I ask forgiveness. Dutch king apologizes for Netherlands' role in slavery. Dutch King Willem Alexander on Saturday apologized for the Netherlands' historic involvement in slavery and the effects that it still has today. The king was speaking at a ceremony marking the 160th anniversary of the legal abolition of slavery in Netherlands, including its former colonies in the Caribbean. Thirdly, we have France and UAE collaborate to accelerate shift towards clean energy amidst the trilateral initiative with India. In an effort to combat the escalating threats of climate change, France and the United Arab Emirates have joined forces to expedite the transition to clean energy solutions. French Trade Minister Oliver Beck recently expressed the shared commitment of both nations to tackle climate change head on and emphasized the importance of accelerating the shift towards sustainable energy sources. Beck lauded the strong partnership between France and the UAE in working together on various initiatives aimed at reducing carbon emissions and promoting environmentally friendly practices. Next up, we have International Plastic Bag Free Day. The International Plastic Bag Free Day is held on the 3rd of July around the world to spread awareness that a plastic bag free world is possible and that sound environmental alternatives to single use plastic bags are available. The first International Plastic Bag Free Day was observed on the 3rd of July 2008 when Rezero, a member of Zero Waste Group, initiated it. Zero Waste Europe, sorry. The holiday was only observed in Catalonia in its inaugural year. However, a year later, ZWE introduced the International Plastic Bag Free Day to the European Union. Next up, we have ESS Euclid Space Telescope launched. Euclid will image light that has traveled for 10 billion years, build the most accurate and largest map of the cosmos, and scientists hope provide insights about the dark universe. By looking at how space has evolved over time, astronomers want to learn about dark energy, the mysterious cause of the universe's increasing rate of expansion. The mission will also study the invisible hypothetical form of matter in the universe, dubbed dark matter. Now, with regards to the legal updates, we have petitions under Section 482 of CrPC not maintainable for challenging proceedings under Section 12 of Domestic Violence Act. Now, the Himachal Pradesh High Court, in the case of Sanjeev Kumar and others versus Shushma Devi, reiterated that petitions under Section 482 of CrPC are not maintainable for challenging the proceedings under Section 12 of the Domestic Violence Act. The Himachal Pradesh High Court has issued directions to the lower courts to ensure their compliance in handling cases related to Domestic Violence Act. A bench of Justice Jyotsna Reval Dua noted that these days diverse recourses are being adopted to challenge proceedings under the Domestic Violence Act in the form of petitions under Section 482 of the Code or Section 397 read with Section 401 of the Code, and sometimes even under Article 227 of the Indian Constitution. So this was all for today. For pre-study materials and TNA PDF slides, please join our Telegram channel, the link of which you can find in the description given below, or you can always scan the barcode that is given on your screen. Don't forget to subscribe our channel on YouTube to stay up to date with the thorough newspaper analysis that comes out every day. Thank you.